Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about criminal law cases where the accused is found not criminally responsible for reason of mental disorder. This was the verdict just handed down in a tragic case from Toronto. The facts of the case are horrifying and will likely be disturbing to most viewers. On June 17th, 2022, Tenzin Norbu entered a bus in Toronto where he approached Naima Dolma, a young nurse who was sitting at the back. The two were strangers, but Norbu suffered from untreated schizophrenia, which had been misdiagnosed. Norbu, who is Tibetan, was allegedly suffering from paranoid delusions about threats from other Tibetan people. When Norbu entered the bus, he asked Dolma if she was Tibetan. She replied that she was, and a few minutes later, Norbu dumped a mason jar of lighter fluid on her shirt and lit it, setting her on fire. She ran from the bus, and while more than 50 people were present on the platform, only a few came to her help. She died 18 days later from her injuries. Norbu was charged with first-degree murder but pleaded not guilty. Both the Crown and the defense agreed that Norbu should be found not criminally responsible for reason of mental disorder. The court agreed, finding that Norbu suffering from schizophrenia that made him incapable of appreciating his act was wrong. Norbu will now appear at a hearing before the Ontario Review Board, which will determine the hospital where he will be held. Here today to discuss this case and the law around findings of not criminally responsible are two criminal lawyers, Joseph Neuberger and Kabir Sharma. Thank you both so much for joining me today. Kabir, let me start with you. One of the things that stood out to me so much in this case was that both the Crown and the defense agreed that Norbu was not criminally responsible. How unusual do you think that is?
In my experience, Christine, it's not that unusual. It really depends on the reports that are authored by the forensic psychiatrists that do the analysis of the individual. Oftentimes, we have to remember that the Crown not only has a duty to the public, but also has a duty to the accused person. So if a report outlines specifically that that person was suffering from issues that would lead to a not criminally responsible verdict, then they're obligated at times to join the defense and presenting that to the judge.
Joseph, what do you think? Do you think that this was a clear-cut case of not criminally responsible for reason of mental disorder, and that's what maybe led to this agreement by both the Crown and the defense?
Yeah, there seemed to have been a robust history of mental illness and documented treatment where he was misdiagnosed with depression and other issues. But there was a long history of a psychotic disorder rooted in a number of themes. So there was a lot of information for the assessing psychiatrist to look at and then provide the opinion on.
So, Joseph, what kind of things does an accused person need to demonstrate in order to make out this defense of not criminally responsible? You've mentioned the forensic psychologist, but what other things might they need?
So typically, the most important aspect is that there is some external evidence that can be relied upon that an assessor can look at to determine if there is, what the diagnosis is and what the condition is. And there will also be outward behaviors that will be obvious to a number of onlookers. So critically, you have to have a forensic psychiatrist, and usually there's a team. There's a social worker involved, a psychologist. They'll gather up medical records if they're available, other assessments, and look at that material. And then there's going to be in-depth assessments and interviews with the individual who's charged. So typically there's an in custody assessment, so they will be transferred to a mental health facility where they're observed and they undergo all these assessments. And at the end of the day, experienced clinicians will arrive at a conclusion. So in this case, as we've mentioned, there was a long-standing history where the particular doctor found he might have been suffering for about 10 or 20 years. So when you have all that information, that's sufficient for a report and an opinion on NCR.
Now, Kabir, we've mentioned a few of the facts on the ground or the background of this long history. The forensic psychiatrist. I mean, the act itself of what happened just sort of kind of speaks to mental illness. Is there? We've only got about 30 seconds. Is there any other fact that stood out to you that would have been helpful in having the court reach this conclusion?
I think in this case, there were a lot of other individuals who were able to observe the behavior on the bus. So the psychiatrist was able to have a sufficient amount of evidence to make the determination, like how Joseph said, independently. You heard what he said, what he did afterwards,
Hmm.
and the way he was acting in general, which I
Yeah.
think in these circumstances was very helpful.
We've got to go to break, but we'll be right back.